Earlier today, I realized that witness intent call today was interviewed by police and it was recorded.
There is not an indication in the report that that review or that interview was ever recorded.
Then why didn't any attorney prior to you ask the people for that information? Because the responsibility to also uphold your client's due process rights rests with your office. And you guys have had this case for quite a while now. If you're going to come at somebody, you better bring it, because I don't tolerate anything in between. Court does call the case People versus Corey Folk.
And Lord Yagi, Assistant Public Defender with and on behalf of Corey Folk, who's approaching. Could you say your name for the court?
Sorry, time set for preliminary examination. Are we ready to proceed?
People are ready to proceed.
No, Your Honor. If I may be heard, I know we had a bench conference about this case. Just to put on the record, I indicated that I felt, given the voluminous discovery in this case, I felt unprepared to proceed to exam today, especially given the nature of the charge and the people's representations and just how much discovery there is and how complicated this case is. And as I was sorting through the discovery earlier today, I realized that witnessable intent call today was interviewed by police and it was recorded. And that was not disclosed to either side. My position is, Your Honor, that it is a discovery violation under 6.201, recorded statement pertaining to a lay witness. That is mandatory disclosure. And I looked up some case law where there's support for some sort of remedy, which includes either precluding the witness from testifying or giving the defense an opportunity to review the discovery beforehand. So I would either ask that the court prohibit the witness from testifying because we don't have the recorded interview with police. And I should note also the police actually implicate the witness, I think, based on the notes that are there in terms of what actions the witness may or may not have taken, their motive, their credibility as it relates to the actual allegation, which is of the utmost importance in this type of case, the credibility and the reason why they're testifying, if they're subject to any criminal charges themselves based on their actions or inactions. And my position is either
making your argument that it's a violation. Are you saying that the people knew?
Well, Your Honor, they should have known. And if they,
well, yeah, you're saying they knew.
I don't know whether they knew, but it is mandatory disclosure and it's the officer in charge of the investigation, I think.
Go ahead with your argument.
So, again, there's a recorded statement with a police officer. Neither side has, under People P. Jackson, 292, 583, as well as related case law.
And that there's an interview with this individual, correct?
That's correct, Your Honor. There is not an indication in the report that that review or that interview was ever recorded.
Well, if I may, one of the indicators that sort of flagged my attention is why did they go to his house but have him go to their patrol car to do the interview?
Then why didn't any attorney prior to you ask the people for that information? Why at this last minute do you come forth trying to indicate that there's some violation and some penalty that should be attributed to the people? Where were your attorneys before now?
I can't answer that at this time, but what I can say is I did reach out to the people yesterday. I sent 2 emails about this case. I didn't get any response. So even if not for any other reason other than at least, and again, yesterday was a holiday, like none of us were required to work. So I'm not faulting Mr. Cook. I'm not faulting the people for that. But I think that it is, at this point, a due process issue. And it's an issue that if
a due process issue created by whom? If you're going to claim that your client's due process rights are violated and that it happened here, you better bring it, Ms. Yagi, because the responsibility to also uphold your client's due process rights rests with your office. And you guys have had this case for quite a while now. So I'd be careful about where you want to point fingers on that line. I'll let you continue if you want to continue right now, but you better be careful.
If I may just have a minute, Your Honor.
You can take as much time as you'd like. Court does call the case People versus Corey Folk.
Good afternoon again, Your Honor. Bringing book for the people.
Public defender with Corey Folk standing to my right. Do you say your name to the court? Folk.
All right. Record should reflect we've had a couple of in-chambers conferences regarding this that have gone throughout the day and trying to resolve some issues. I think well, I'll let you say what you're going to say. Go ahead, Mr. Cook.
Thank you, Your Honor. I previously indicated the people were able and ready to proceed today. I would note that as of now, that is no longer true, as one of the people's necessary witness, a witness that I believe has been the subject of much discussion for this case, has left the courthouse and is no longer responding to attempts to communicate with him or to reach out and find him. We are unaware of his whereabouts at this time. As such, the people are not ready to proceed at this time with that witness. And I believe previously defense counsel referenced a desire to adjourn so that way she could have more time to review the case, as well as for the parties to usually go over some of the found discovery that exists that both parties like to review as it relates to that potential witness's testimony. I did also want to make a brief record related to that additional discovery, as there was a claim that the people, I believe, the term used was a discovery violation, or that somehow the people were withholding this discovery. I want to make it clear that I did not know this existed until today, when Ms. Yagi dutifully was looking through the available discovery and inquired about whether this particular item existed. I asked the officer in charge whether that item does exist, and he indicated that it did, but he did not believe he ever sent it to our office. Nevertheless, I asked him how soon that would be available, and he indicated that it should be able to be copied to a disk and provided to both the people and defense by the end of the week. And I will make sure that that gets done as soon as time allows. I would also just note, again, this is not important to the court's decision today or the people's request, but just making a record. In the report, there's the original report as well as numerous supplemental reports. And of those reports, there's indications of body cam being on some of those reports, but not on the report that would have the interview of this witness. So there was no mark on there. Body camera was on a recording. And so I did not think that there was any until I discovered that it was today. As it stands, I would be joining at this point with defense counsel's request to adjourn the preliminary examination for today. I believe that the date we had discussed was June 15th at 9 a.m. I have confirmed that that date works. With 3 out of the witnesses, 1 witness is unavailable, but I am confident being able to proceed without that witness. And I was not able to confirm that date with the missing witness for obvious reasons. I believe that's where we stand, and that's the people's request.
One other thing, I'll just indicate that there might be a request for a material witness warrant should the people feel that's necessary, given the individual having left and them being under subpoena. Ms. Yagi.
Yes, Your Honor, that is correct. And I will certainly follow up regarding the outstanding discovery.
And let me, just for the court's purposes, say this. I was dealing with this all day from different perspectives and different angles and seeing what we could accomplish today and could we go forth today. I watch and preside over week after week, where I will watch 2 of what I believe the state's most efficient offices in terms of what they have to do in our criminal justice system, that being the Washington County Prosecutor's Office and the Public Defender's Office, and that to watch them work tirelessly to try to make sure that all of the evidence, everything is provided, when certainly there could have been a point, not saying that they would, where the people might say, well, we don't have to worry about that piece of evidence. They voluntarily disclose that there's this other thing out there that may not even belong to a police agency, might belong to a third party. Let defense counsel know, and they endeavor to get all of that. Now, I say that because, and I didn't hear everything on it, but I assure you, Mr. Cook, that when the representation was made that there may have been some intentional non-disclosure, I think by my reaction, I think you should have understood. I don't buy it. I don't believe that's what happened in this case at all. I don't believe that you knew, as you've indicated. I think that it's one of those things that's there, and quite frankly, in reading the report, is going to be equally as plausible to the defense, who could have then made the request, as it would have been to you. And so that's the way that this court's going to handle it. And as I said, and I'll be frank with you, Ms. Yagi, if you're going to come at somebody, you better bring it, because I don't tolerate anything in between. Preliminary examination in this matter is adjourned June 15, 2026, 9 a.m. before me. Bond will continue. Thank you.